Good evening, friends. As we started the celebrations of 75 years of Constitution of India, needless to add that once you are enjoying and celebrating the 75 years, there can be a better person than Mr. P.S. Rajagopal to add the shine in that 75 years of celebrations. And since there were also a lot of demands to the effect that we should also do the sessions on Constitution bench, especially with reference of the judgments which find place in the Advocate on Reports test, we requested Mr. Rajagopal, who undoubtedly is one of the authorities under the constitutional law. And his constitution within the series of 75 years can't be dispensed with. He's an indispensable part once beyond laws. CLC is taking certain sessions, and you have to make request to him. And before your request reaches him, he exceeds prior to that. So on behalf of Beyond Law CLC as well as Recruitment Associates, we are thankful to Sir for sharing his insights despite his busy schedule. Tej Prakash Pathak and others versus Rajasthan High Court and others is an important aspect as to how the rules of the game, whether it can be changed in respect of a selection process once the game has begun, or whether the rules of the game can be changed once the game is over. There was a dichotomy in different judgments, and there was a lot of debate in this regard. And certain matters were being kept pending on account of this judgment. But now, as they say, in the law, we say, let me rest my judgment on this aspect. Now we hope that this issue has come to an rest, but for those who have been interested to understand the nuance of this aspect, to make it simplified, we have asked Mr. Rajagopal. And over to you, sir, and thank you for accepting our invite.
Thank you, Vikas. Thank you, Trivikram. It has been a great experience for me to be sharing whatever little I know with law persons. I do not, because we get on our webinars, some non-advocates also who are interested in law. Sometimes we get, particularly when I spoke about sanctioned previous approval in criminal law under the Prevention of Corruption Act, I could see online more number of police officers than advocates. Therefore, I would not like to use the word to be with the advocates, but to be with the persons interested in law. It has been a great platform that Vikas and his friends have been providing on Beyond Law CLC. Now, Trivikram and his friends at Bangalore are also making efforts to activate. I would not like to start or anything, because it is quite a old academy we have, which was lying dormant. Now a decision has been taken there to activize it. This is the importance of these webinars is, these are the forum where speaker also learns from the questions asked, and audience would be able to brush up their knowledge. We are not, if I'm speaking to advocates, I cannot say that I am teaching something about Tej Prakash Pathak, because Tej Prakash Pathak, according to me, even reference itself was not warranted. But more important than reading, it is the exchange of views that take place in webinars that really adds value to the continuing education process of advocates. Because I always tell that had I known that I would be required to read for so many hours every day, I would never have become an advocate, because I was a very poor reader as a student. I would read only 7 days before the examination. I would just gather all the textbooks and start reading. Now, after becoming an advocate, rightly or wrongly, I have now come to realize that this involves more reading than facing an examination, because every day we face an examination, not only in the court. When a client comes and asks a question, sometimes it will be as difficult as university examination, or even little more, because university examinations are conducted according to a syllabus. whereas the clients and advocates who meet the senior advocate, they do not come with any syllabus. Their case is my syllabus. Therefore, every day I have to be adjusting to the new syllabus. Now, friends, coming back to Tej Prakash Pathak, all of you, please remember one very fine aspect of how the reference arose, how the reference was answered. That is about the academics. More importantly, all these judgments, or at least majority of them, which have been rendered on rules of the game, they arose from either recruitments made by the high courts or recruitments made to the, I would not like to use that subordinate judiciary, use the phrase. Now it should be eschewed for the posts of civil judges by the public service commissions on the basis of guidance issued by the High Court. Now take, for example, the root of this reference. Root of this reference is Subash Chandra. That was a case where the question involved was recruitment to the post of civil judges made by Haryana Public Service Commission based on a letter written by the Chief Justice Punjab High Court when Punjab in recruitment happened in Punjab. Then comes the Manushi. Manushi is a case which arose from direct recruitment to the post of district judges made by Andhra Pradesh High Court. In Manushi, 3 judgments were relied upon. Principally, reliance was on Umesh Shukla. That was a case arising from recruitment made to higher judiciary, that is a district judge's post, by Delhi High Court. All these cases arose not from any recruitment made by either the state government or a state-owned corporation, but by the judiciary itself. Now, this can be looked at from 2 angles. One is whether high courts did not know the rule, or whether the high court, the constitutional court which corrects the wrongs of all other state actors and in civil and criminal disputes in matters about the cases of the citizens also, whether High Court can be so ignorant of the rules. Other way of looking at it, particularly in 75 years of Constitution when we are celebrating, we have to look these issues from the perspective that there is rule of law in the country. Even if the High Court has committed a mistake on administrative side, the High Court on judicial side will not hesitate to annul it if the action of the High Court on administrative side is contrary to the constitutional principles. And Supreme Court will not hesitate to set aside decision taken by anybody, including the High Court on administrative side, which is the hallmark of rule of law. Because before law, all are equal. Everybody has equal protection of laws and equality before law and equal protection of laws. That is one reason to celebrate the judgments regarding recruitments, which went from recruitments made by the high courts themselves. Now let us take the case of what was I was telling at the threshold that there was no need for reference to 5-judge bench at all. Because what was the issue in Subash Chandra and what was the question in Manushi. Both these judgments are by 3-judge benches. In Subash Chandra Marwa, the question was this. The recruitment process was completed and the minimum aggregate marks to be secured in written examination and interview for being eligible to be selected was 45%. Recruitment notification was issued stipulating that it is 45%. Candidates took the examination and interview in the belief that it is 45%. But when appointments were issued, select list was issued on the basis that it is 45% minimum. But the High Court decided that only those who have secured 55% or more, they will only be appointed. Then whether in answering the question, whether in the face of 45 marks, 45% stipulated for being eligible to be placed in select list, and all such persons having been placed in the select list, was it open to the High Court to appoint only 55, those who secured 55% or more? What answer Supreme Court gave, we will examine little later. But in Manushi, the question was totally different. What had happened in Manushi was that recruitment process was initiated by issuing a invite to apply that we call as normally recruitment notification or advertisement or whatever you want to call it. What it stipulated was there will be 100% marks for written examination, followed by viva was say for 50 marks. There was no minimum stipulated to be secured by a candidate for viva was. On the basis of written examination results, whoever becomes eligible, they will be called for interview. Marks secured in the written examination and interview will be added up, and the merit list will be prepared on the basis of total marks secured in written examination and interview. The written examination was over. On the basis of the merit secured in the written examination, interviews were conducted, calling those who have secured more than a minimum mark stipulated. While making the select list, the High Court by a resolution resolved two changes. One change was to maintain the ratio of 75% for written examination and 25% for viva voce. Evaluate the marks secured in written examination on the basis the maximum marks itself is 75. The examination was written for 100. The evaluation was for 100. Then recruitment notification also said it was 100. But in making the merit list, weightage for written examination was reduced from 100 to 75. Then for the 25 marks interview, neither the rule nor the advertisement stipulated any minimum marks in interview. Because though we have been saying, we are not tired of saying that written examination tests the knowledge of the candidate, whereas the interview tests the candidate himself or personality of the candidate himself. And in Leeladhar, Supreme Court went to the extent of saying the twain shall meet, because the aspects that are evaluated in written examination and viva was said they are different, they are distinct, let there be no confusion, but there can be fusion. All these things were told. But still, with all proclamation in favor of the merits of a viva voce, it still remains a fact that normally the minimum marks in viva voce, if there is a stipulation, it is always viewed with suspicion. I don't know, maybe suspicions may be justified in some cases, but it may not be justified at all, or it may be baseless in some cases. But human uh, approach to the interview is that, oh, there is a minimum marks in the interview, so that if they don't like my face, they will eliminate me. That type of feeling somehow over a period has accrued. I do not know. I would not like to venture and answer whether it is justified or not. But let us go by the fact that there is such a feeling. The percentage of marks for written examination was reduced to 75%. Then 25% for written examination. It was made. The select list was challenged on the ground that you have changed the norms after the recruitment process is over. That is, rules of the game have been changed after the game has been played. That is how this phrase came. Rules of the game. Then when the matter reached Supreme Court, kindly keep this in mind. Insofar as reduction of maximum marks for the written test from 100 to 75, the Supreme Court approved it. In fact, the word used there is, I think Lordship Justice Ravindran wrote the judgment for 3-judge bench. It is unexceptionable. But when it came to stipulating minimum marks for interview, after the interview is over, Supreme Court annulled that action and said that you cannot change the selection norms after the selection is over. At the same time, Supreme Court was cautious enough to say that the employer, unless there is something contrary to it in the rules, can always stipulate the even minimum requirement of marks in the viva voce test also. It is not a taboo. But what is taken exception to is fixing that minimum after everything is over. And there are several reasons why such an approach was required and is required, and it has been followed also in Tej Prakash Pathak. When Rajasthan case came, that is the Tej Prakash case came before the Supreme Court, before a 3-judge bench. What are the facts noticed? Applications were invited for certain number of posts of translators in the establishment of Rajasthan High Court. 7 or so posts were there. 21 persons, not a very large number, because when you call for recruitment to even district judges post, minimum about 1,200 people take part. Therefore, in the translator's case, the number of candidates who appeared for written examination and interview were only 21. After the examination was over, select list was published, wherein it was decided that only persons above 75% marks would be appointed. For a translator, stipulating that they should secure a minimum merit of 75%, I don't think that it is unreasonable stipulation. There was no minimum prescribed either for written exam or for written examination. Only on the ground that the recruitment rule does not stipulate any minimum marks for appointment in the aggregate. All that we expected under the recruitment rule is that the marks secured in the written examination, marks secured in the viva voce will be added up, and we will be appointed in the order of merit. Therefore, you have changed the rule of the game. That was the case projected in Tej Prakash. The issue raised in Tej Prakash was wholly different from issue raised in Manushi. And issue raised in Tej Prakash was exactly same as raised in Marwa's case. But the three-judge bench, when this matter went before the three-judge bench, I think Lordship Justice Chalameshwar wrote the order of reference. He said that the three-judge bench in Manjushri has not considered Subash Chandra Marwa. Fortunately, used the phrase, was not placed before the bench in Manjushri. It went by Umesh Chandra Shukla and another Durga Das from Orissa. There is a conflict. The three-judge bench, there is a conflict between Subash Chandra Marwa and Manjush. Therefore, the matter was referred. And the reference order is of the year 2008. Sorry, this is the reference order is 2013 4 SCC 540. After 12 years, I am happy that the Constitutional Bench has resolved it. What it said, why these rules of the game concept came. There is what is known as legitimate expectation in administrative law. What is a legitimate expectation? As long as the government or governmental agency holds out that we are going to act in a particular manner, this will be the qualification, this will be the process, these are the number of posts to be filled up. The state is expected to act in accordance with what it holds out. And now earlier, some years ago, legitimate expectation was not treated as an enforceable right. Subsequently, from Kamadhenu feeds onwards, legitimate expectation has become an enforceable enforceable weapon in the hands of the citizens. First thing is that they should act to meet the legitimate aspirations and legitimate expectations. At the same time, what is not based on law is not legitimate. Take, for instance, that one judgment which arose from recruitment of district judges. Mansoor something is there that there is judgment. Even now you will be seeing series of judgments coming in that title about the recruitment of district judges. Regarding the age relaxation, there was something stated in the recruitment notification which was contrary to the recruitment rule. Rule says something, the notification says something else. Then the question came before the Supreme Court. I think Lordship Justice Y.K. Sabharwal. He said, if there is a divergence between recruitment notification and the recruitment rule, it is the recruitment rule that would prevail and not the recruitment notification. And anything stated in the recruitment notification, contrary to the recruitment rule, does not give any right. That is based on the premise that an expectation which is not based on law can never be a legitimate expectation. I had a very interesting experience about legitimate expectation. In MS Ramaya College of Law, now it is a university, private university. Certain students had serious shortage of attendance. When they, at the time of, before the examination, they were not, when they were denied admission to the examination, they came before the High Court and said that all earlier years, they have condoned shortage in attendance. Therefore, we legitimately expected this time also that our shortage in attendance would be condoned. Then it was since it was a matter which was going to have a very serious impact on study of law in the state of Karnataka. Court requested me to assist the court as a friend, as amicus. I appeared and my submission was any expectation which is contrary to law can only be an illegitimate expectation and it can never be legitimate expectation. Of course, some authority also relied on for that purpose. Because it was a very embarrassing situation for the university also. If the university or the college accepts, yes, in the past we have condoned, uncondoned, non-condonable shortages, it will be showing the college in very poor light. At the same time, the court cannot allow, merely because you have done some illegality in the past, repeat the illegality this year also. Therefore, brushing aside that question, I said, under the university statutes, this is the minimum requirement of attendance. If somebody has not met those minimum standards, then the expectation that it will be condoned, apart from being beyond the powers of the university, it would be an illegitimate expectation. That was accepted, and then they were told that you cannot have any legitimate expectation contrary to law. Therefore, what the basis of rules of the game concept is legitimate expectation. Second is requirement of Article 16(1). What is clause 1 of Article 16 say? Equal opportunity in the matter of public employment. Yes, there can be qualifications stipulated. There can be process stipulated. There can be number of vacancies for which the recruitment takes place stipulated. By making an application in answer to recruitment notification, there is no guarantee that he will be selected or appointed. But only guarantee that the Constitution assures every citizen is that his candidature will be considered in accordance with law. The second aspect of why rules cannot be changed. Then third is, of course, this is not mentioned in Tej Prakash Pathak, but as students of law, all of us we should know this. The fundamental aspect of law is that law must not only be made, but it must be made known. Number one. And second, it must be made known in good time. That is, before I offer my candidature. Then Supreme Court in Marwa's case justified the action in appointing only those who have secured 55% or more by making a fine distinction between eligibility and suitability. Now, what is eligibility? As to who will be eligible to be placed in the select list. That is the eligibility. Everybody who secures an aggregate of 45% marks as per rules are entitled to be placed in select list. That aspect is perfectly valid. When it comes to suitability, High Court found that to enhance the quality of judicial officers. Even though those who have secured more than 45% are placed in the select list, I will offer appointment only to those who have secured more than 55%. That is a suitability benchmark that I am going to fix. And it said, as long as there is no arbitrariness and inter se those who have secured 55% or more, appointments have been made in the order of merit. No exception could be taken. And another most important, the aspect is that merely because the state issues an advertisement inviting applications for a certain number of posts, and merely because there are adequate candidates placed in the select list, there is no assurance on the part of the state that all the vacancies will be filled up. State is free to fill up all vacancies, or it can altogether not act on the select list at all, and they may say, we have changed our policy. Therefore, right now we are not going to fill up any post. All that, the only requirement is that rejection of the select list or refusing to make appointment in the select list should not be arbitrary, and it should not be capricious. That is Sankarshan Das principle. Principle in Sankarshan Das is this: the employer always has a right not to make any appointment or make only a few appointments against the number of vacancies notified. But the refusal to appoint should not be arbitrary. Secondly, if appointments are to be made from the select list, the order of merit, subject of course reservation matrix, cannot be changed. These two principles were applied in Marwa's case. Whereas the questions which arose in Manushi are totally different. The issue, fair and square, in Manushi is this: having administered the recruitment process on the premise that there would be no minimum prescribed marks for the Viva, say, whether the High Court was right in stipulating a minimum percentage of marks at the time of preparing the select list. That was held to be bad because it is the contrary to fundamental principle of administrative law, that is fairness in action. Because we have so many judgments and all that. One phrase you always come across in administrative law is that every deviation from rule need not be corrected in the jurisdiction. Ultimately, you apply the principle of prejudice, whether prejudice has been caused. Then the question is not the basic principle is, if you change the eligibility norms, suitability, you can always fix a higher benchmark than eligibility. Here in Manushi, the eligibility concept or eligibility norm was that once you become eligible to take Viva examination, your right to be included in the select list will be decided by aggregate marks you secure in written examination and Viva. The question of suitability did not come there. Therefore, the law as crystallized even in Subash Chandra and as reiterated, though not referring to it in Manushi, is that the eligibility norms cannot be changed. Now, reconciling, or there was no need to reconcile also. What the Supreme Court said, Constitution bench, its judgment will have to be valid for a little longer period. Therefore, Constitution bench in Tej Prakash Pathak not only said that there is no divergence between Subash Chandra and Manushi. They speak the same language. Only thing is they answer different questions and answers were definitely different. Then it quoted some paragraphs from Manjushri to say that even Manjushri also spoke same language. Even in Manjushri it said the right to prescribe the minimum marks for interview is not illegal. Only question is at what point of time that right has to be exercised. And one fundamental thing they said was that you can do, you can always act, you should always be acting in accordance with the rules. Apart from the rules, for example, let us take a case where for 100 posts, you receive 10,000 applications. Then some method will have to be found to see that selection mechanism does not become a farce. And selection mechanism must be manageable. Then in such cases, suppose the recruitment notification says minimum percentage of marks 55% in the graduation or post-graduation, as the case may be. You call for written examination or you call for the recruitment viva test, only those who have secured more than 75%. It is a bona fide act of shortlisting. Supreme Court at paragraph 50, please read paragraph 52 and 53 of the report in Tej Prakash Pathak. It clearly says, in the norms in the mechanism of selection, sufficient freedom is available to the employer as long as it is not contrary to the rule. Shortlisting may be there, where even after prescribing your right to be included in the select list at a particular level, the employer can always say that, yes, this select list has come. I will not appoint those who have secured less than 60% or less than 70%, depending upon assessment of the needs of the service. Ultimately, the objective of any recruitment is to select the best amongst available candidates. Now, there is another reason why rules cannot be changed after the game is played. Now, for each stage, there is a last date before which you can do. Suppose a recruitment notification is issued stipulating a particular qualification. Say, he must be having 3 years experience or 5 years experience. Take the case of direct recruitment to the cadre of dean or director of a medical institution. The rules stipulate, the rules made by the Medical Council of India, now they are calling as, National Medical Council. What it says is, a person should have taught for 10 years, out of which at least 5 years as professor. That is the norm of eligibility for applying to the post of dean or director in the medical college. Now, after issuing the recruitment notification, suppose the employer finding only 2 or 3 applications have come, they are not enough to have a competitive assessment of the candidates. Therefore, I reduce the experience as professor to 3 years. That will be a fraud on power. If you make that change before the last date for submission of the application, everybody who has 3 years experience as professor would have an opportunity to apply. But if you, by an internal note, change the NRM, or even by a notification you change the NRM, after the last date stipulated for submission of the applications is over, persons who have even 4 years experience, or 4 years, 11 months experience, or 3.5 experience, 3 years experience, or even 3 years experience, they would all be deprived, except perhaps the brother-in-law of the person issuing the notification, because he might have foreknowledge that ultimately these people are going to consider even 3 years persons. Though I am not eligible, I will apply. That will be a fraud on court. The qualification, it cannot be changed once last date is over. But shortlisting will arise only after the applications are filed. That too, shortlisting can be done if there is a provision in the rules or if there is no prohibition in the rules. Because when rule is silent on something, it is law right from 1967 as declared in Santaram Sharma. Gaps in the rules can always be filled up because rulemaking authority would not have envisaged every situation that we may encounter in implementation of the rule. Therefore, gaps can be filled up, but the rules cannot be supplanted by administrative instructions, and administrative instruction can only supplement the rules. Therefore, wherever rule is silent, enormous freedom is available, subject to not changing the eligibility criteria, and subject to consideration of every case in accordance with the law as prevailing on the date of the notification or as notified. But in the matter of norms for selection, that is like shortlisting and all that, or elimination, you can always have an elimination test included, provided that there is no prohibition in the rules. Therefore, what Tej Prakash has said in some substances, there is no divergence between Manushi and Subash Chandra. Both are right, but they operate in different fields. Marwa operates to decide on suitability, whereas Manjushri decided the question of eligibility, and because eligibility there was prior to the full court resolution, everybody, irrespective of the marks secured in the written exam, in the Viva was eligible to be placed in the select list. Now, by stipulating a minimum pass mark for in Viva was you have changed the norms of being eligible to be placed in select list. Whereas Subash Chandra Marwa did not make any change up to the preparation of the select list. After the select list was published, it said that I find only those above certain norms as suitable from amongst the persons who have become eligible for appointment. That is why in some of the recruitment, at least in most of the recruitment rules, you would find that placement in select list does not give you a right to be appointed, number one. Number two, appointment will be subject to, the appointment shall not be made by the government unless it is, after such inquiry as may be necessary, finds the candidate suitable. Of course, after such inquiry as may be necessary, that may be regarding your reservation certificate or whatever it is. But operating part of that rule is suitability to be appointed. Suitability can be a little higher than the eligibility. Therefore, this is the distinction drawn by the Constitution bench that eligibility and suitability are different. Rules of the game commences with issuance of the detriment, and though it is not so clearly stated, game ends with publication of the select list. Thereafter, appointment is something, it is a different process. That is, you can apply a higher standard of suitability at that stage. I think I have tried to cover what is said in Tej Prakash and what flows from Tej Prakash, because one thing I always believe is not knowing the law is important, but more than knowing the law or more than knowing what is law, it is more important to know why is law or why the law should be like that. What would happen if the law is not like that, if it is something totally different? That is what makes us more effective as advocates and as students of law. Of course, as we move higher, we can say why of the law and logic of the law, rationale of the law. If you know all this, you will be a jurist. If you know only what is the law, you will be only an advocate. We should all try to evolve to being jurists, because that is the way the quality of advocacy will have to be improved. Thank you very much. Questions, please.
Thank you, sir.
Subject to what Vikas and what Trivikram would say.
So this time I will ask Trivikram to take the question, what he has in his mind. Then I will take questions.
I'm
Trivikram,
just waiting for the questions to come up on the Q&A box, sir. I have also made a mention in the Q&A box. I would also repeat that we are welcoming all the questions and we would route it to the resource person. So kindly shoot your questions immediately. Meanwhile, Mr. Vikas, if you have any question, we can discuss.
like we have seen this in Tej Prakash as well as 700 CT. What do you say that what is the legal significance of a select list in a public employment?
In the public employment, the select list is this. The stage of the select list is you have passed all the hurdles and become eligible to be appointed. That is the meaning of, if you see the rules again, because in service law, rule is most important. After the Viva voce or the personality test, Public Service Commission shall prepare a list of candidates eligible to be appointed, drawn up in the order of merit, subject to reservation matrix. That is what we call as select list. Select list means you are eligible to be appointed and nothing beyond. Eligibility to appoint, we should not confuse with suitability to be appointed, though most of the time, all persons included in the select list are appointed. So, for example, I tell there is a very eligibility how it operates. Of course, that is not a thing that could be corrected by way of selecting, fixing a suitability now, because it will go to very root of the matter. In the state of Karnataka, for recruitment to gazetted probationers posts, for long years, there was no minimum percentage requirement, either in the written test or in the prime personality test. Suppose 10 posts are reserved for 10 posts of, let us say, assistant commissioners revenue. They are notified. 10 persons in the order of merit will be included in the eligibility list, in the select list, because there is no minimum marks. Whereas in the all India services, there is a minimum. Even after you are securing a place in the eligibility in the Viva voce, even after, first of all, to go to Viva voce, there is a minimum percentage of marks you have to get in the written examination. There was no such requirement in the Karnataka rule. Thereafter also, without prescribing a minimum in the Viva voce, you can always say that they should in the aggregate secure a minimum of this much, this percentage to be included in the select list. Therefore, inclusion in select list gives you an eligibility to be appointed. You cannot be thrown out on the ground that you are not eligible. Then comes this character verification, all those things. Earlier days, whether he is a member of any banned organization. I think now also they are doing it. They're checking whether police report and all that. But these days, unless you are a member of a banned organization, that will not come as a. That is why it's always said, inclusion in select list does not give an indefeasible right to be appointed. Have you clarified, because
Yes, sir. Yes, sir.
कुछ
And the
तो हो
next-
गया ना, not fully.
बहुत हो गया.
बहुत हो गया.
It is more than beyond the principles of legitimate expectations. So next is, under what circumstances, interwoven with the previous question, under what circumstances can the employer validly withdraw or cancel a recruitment process?
There are recruitment process would not normally, it cannot be very easily cancelled, though. As I was telling, Sankarshan Das says that there is no obligation on the part of the state government to make the appointment merely because we are recruiting. Sometimes I have come across some 2-3 cases like that where the entire thing was abandoned. There is a case, let us say, inspector of motor vehicles. For example, I am only giving an example, not that it will happen in every recruitment. In some of the states, even today, the rule is a diploma in automobile engineering as well as a B degree holder in automobile engineering are eligible. That being a technical post, no written examination. Only there, sorry, no interview, only written examination or something is there. And on that basis, you make the appointments. Government may decide on the basis of a study that the public service in this state requires only graduate engineers to be appointed as accountants. We are amending the rule. Pending amendment to the rule, since it is going to take some time, we are not making any appointments from the list. If such a decision is taken, though there is no case decided, I think that would be a legitimate exercise of power in public interest. In Haryana, some years ago, recruitment rule was stopped midway. Recruitment process was stopped midway on the ground that we are changing the reservation policy. Either I think immediately after issuing the requisition to the Public Service Commission, it was halted a few years ago. If you scratch your memory, you would remember it, because such a thing has happened in Punjab and most of the judgments are from, I was telling, from either judiciary, judicial appointments made, or earlier days in Karnataka, from Karnataka, present day from Punjab and Haryana. These are the two fertile states in service law. We were fertile, you are fertile. Now there is not that much vigor in our state, because more or less we have settled down. And of course, we can't say that this is final. The recruitment exercise can be stopped any time. Only safeguard or only caveat insofar as stopping it is, you cannot abandon it arbitrarily. And word arbitrary is a very pregnant word. From the date of Maneka Gandhi, procedural due process has taken new dimension in our country. Arbitrariness is something which would include what is discriminatory, what is unfair, what is unreasonable, what is unjust. To put it in a nutshell, any action, including abandonment of the recruitment process, must be a demonstration of fairness in action. As long as your action is fair, you can do it. But we would make every effort as those appearing for the selected candidate to prove that it is unfair.
In fact, this Shankar Das and Tej Prakash, as well as Sevanandan CT versus State of Kerala, they also say that you may have a legitimate expectation, but still, for bona fide reasons, you can cancel the transfer.
You can cancel. See, I did not refer particularly to Shivanandan CT because I feel that in molding the relief, Supreme Court acted contrary to law. In the end, though every argument of Shivanandan was accepted, he was denied relief on the ground that for 6 years these illegally selected people have been working. Does the length of time sanctify an illegality? In fact, in the note prepared for today's interaction, I have included C.T. Sivanandan with my most caustic remarks. Therefore, if I refer to C.T. Sivanandan, I will have to say something about the judiciary also.
Let's, like you said, that the difference between a lawyer and a jurist is that they say that if speech is silver, silence is gold.
Yes. It is better I remain silent on C.T. Sivanandan.
Yes.
Because it is not fairness in action.
So another basic question for the youngsters which we are getting, what is the distinction between right to be considered and right to point?
Right to be considered is that your candidature will have to be examined as per the rules declared in a non-biased and non-discriminatory manner. In fact, this is gloriously put. Right to be considered what it is gloriously put in that Badrinath's case. Government of Tamil Nadu versus Badrinath. Lordship Justice Jagannath Rao wrote that judgment. He said, yes, the government stand was that we have considered his case for promotion and we have not found him fit. Supreme Court answered saying that consideration means consideration in accordance with law. Law means the rule in force. He has to be considered. Suppose a particular candidate, suppose he is given 0 marks in the vivas. Can you say that it is just fair? Your action speaks. Considered means considered in accordance with law. Applying, giving him similar treatment to that you have given to other candidates. In fact, Article 14 in matter of recruitment, I remember to have seen one judgment. In these type of matters, what is expected is similarity of treatment. This particularly arises. What happens is when in some candidates, in respect to some candidates, the additional sheets used by him in the examination were found missing at the time of evaluation. But in the face sheet of the answer book, there would be a tabulated statement saying what are the questions he has answered. Then what is required to be done in respect of those answer scripts, some parts of which are missing? The examining authority decided, suppose he has answered 10 questions in the main answer script, 2 questions in the supplementary answer script. What is the percentage of marks he has secured for the first 10 questions? Give him the same percentage of marks, allot him the same percentage of marks in respect to the answers he has answered in those sheets which are lost. There can be argument and counter argument. You can say that normally a candidate will answer the 2 questions He is thorough within the first part. Therefore, he would have got higher marks. Don't give him the same higher marks for the last additional answers, additional sheets. Answer was, in these matters, what we expect is similarity of treatment and not identical treatment. Similarity of treatment is one of the concepts of consideration in accordance with law. Consideration in accordance with rule is another thing. And then consideration in accordance with law is, it includes interview by a biased person, like we have in, which is that Ekak Kripak, where one of the candidates for promotion himself was a promotion committee member.
And
Supreme Court reject.
Badrinath also discusses regarding the doctrine of necessity has been extensively discussed. Ranjit Singh Karnam also discusses doctrine of
Yes.
necessity and doctrine malice in fact and malice in law.
That is different, man. That is the doctrine of necessity. Is that is the last weapon in the hands of the managements. Suppose
participation was also discussed in the Ashok Kumar Yadav.
yeah, Ashok Kumar Yadav.
Also,
that they said as long for a members of the Public Service Commission, it is enough if they recuse from interviewing their relatives. But most of the places, the rule has been, the practice has been this. Before being a member of the interview panel, he has to give a declaration that there is no candidate who is related to me participating in that selection.
Somewhat akin to Section 12 of the Arbitration Act, where where the declaration is to be I know this thing.
And then annexure, the appendix 5 or whatever it is.
Where to come out of that, wherein it says that justice must not only be done, but is seen to be done. And nobody can be judged in its own case.
Yes.
Yeah. So this is by Muhammad Shami. Would change in any other notification, stipulation or recruitment rule other than those relating to eligibility criteria amount to change of rules of the game?
That depends upon what is the change brought up. Suppose percentage of marks, it is a question of eligibility. Then suppose you introduce an additional filter. That depends on the nature of the filter, whether it will be valid or not. For example, in Rajya Sabha Secretariat or something, yes, I think in recruitments made to Rajya Sabha Secretariat, certain marks were given or certain weightage was given to the knowledge of computer operations, though it was not there in the recruitment notification. It was included in the interview call letter where they said you bring all your certificates in of experience in computer operations, and a certain weightage was given to that. There the Supreme Court upheld it, saying that it is public interest and there has been similarity of treatment. But similarity of treatment cannot go beyond a particular point. It would depend on what are the changes we have brought in.
Vikram, any question from your side?
As of now, no questions. But I would request, I would request you to unmute Dr. Mohan Rao Valla. So from his end, if we have any questions, we'll just try to check.
So meanwhile, we will take one ordinary, like you were ending up the session on the effect that a difference between a lawyer and a jurist. So what, according to you, makes a difference between an ordinary and an extraordinary lawyer, or a difference between a lawyer and a jurist to make his mark within the profession? What steps he should take to somewhat create his niche within the profession?
What I don't believe in this ordinary, extraordinary, because I always believe in one thing. We got freedom by the extraordinary feats of ordinary men. No noble laureate participated in the freedom struggle. Maybe one example, one exception is Ravindranath Tagore. Otherwise, the constant urge to do justice to your client honestly, not by dishonest means, would make every advocate an extraordinary advocate. Always I feel that because there is not much of a difference between ordinary and extraordinary in the field of law, because let me tell my own case. I just secured 37 or 38% in the LLB and passed. That was those days, not 40%. And I have friends who secured gold medals also. Ultimately, it is a constant effort that makes you look extraordinary. I am not saying that you are extraordinary. I am saying that you would look extraordinary by your effort. The difference between ordinary and extraordinary, I would substitute the word advocate with ordinary and extraordinary presentation is preparation and honest belief that your client has an unbeatable case. We know our experience may be different, but we should at least believe when we stand up before the court, yes, my case is sound. Corridor में कुछ भी बात करो, no problem. When you go inside, go with this conviction. Then you can turn every opportunity into an extraordinary opportunity.
We can sum up in the way that they say that the greatness of great men does not lie in the sudden flight. It is others while who sleep at night. They take the sudden flight of working. Yeah. So thank you. It was always, as usual, an enlightening session. And these remarks, which actually lit up the fire within the belly of everyone, is what we learn from you. As you already said, that it is as good as habit. First it is it, then bit, then a bit, then it becomes a habit. So keep working hard, keep shining, and keep.
And in fact, sorry to interrupt. Before we wind up, I wanted to say, rightly in the beginning of this webinar, you told there is a shine. And sir has been a star throughout, and his webinars have been very shining throughout, and our audience have been waiting for his webinars. So that I wanted to reiterate and mention at this time.
That's true. Thank you, everyone. Stay safe, stay blessed, stay connected.
Thank